and we can get started. Thank you everyone for joining us today. We're joined by Diana Wiles, who is Associate General Counsel for Prince George's County Public Schools, and Megan Jones, the Managing Attorney at Disability Rights Maryland. Thank you both so much for being here, and we're looking forward to your presentation.
Thanks, Peyton.
Thank you.
Let me try and get this Zoom screen out of the way so I can advance our slide here. There we go. All right. So we wanted to start off by talking about some strategies for understanding and working with pro bono clients. I think the first bullet point on this list is something that's just generally good advice in all cases, which is to define the scope of representation up front, but especially in cases like those that will be done through the MVLS special education program. There are very limited issues which are able to be served under the program, and so making sure that you're clearly defining the scope of your representation to align with the issue for the family that qualified for the MVLS special education program. We also recommend being prepared to use less formal methods of communication and specifically text messages. One thing, especially in rural Maryland, I have many clients who don't have internet in their home, and not because they don't want it, but because it is just impossible in that particular location of Maryland to get internet connectivity, even with hotspots, so parents are not always able to check email at their home. And I have some clients who are not always able to answer cell phones at their home. So for those clients, just making sure that you establish upfront the best way to communicate with them, so that you know if the family is one that you need to actually text the parent so they can get to the one spot in their house that has cell signal, or so that they can go to the library to access the document you sent them to sign, etc. We also recommend, especially again when working in rural counties, that you partner with local supports like Mobile Crisis, who may be working with the family, like Maryland Coalition of Families, folks who have an ongoing and existing in-person relationship, and those are folks who we will often rely on to help get signatures on forms, or help if the parent can drop off records to them, they can scan the records to us, and that can help with communication and follow through. We also recommend helping empower the parent or guardian to learn how to advocate for the student while you are providing your representation. And so especially in cases like those that qualify for the special education program, like I said earlier, when it's a limited issue, it's especially important to make sure that when the parent has issues arise that follow your representation, that you've not just helped them with the issue, but that you've given them the tools to help advocate for themselves in the future, whether that be the tools to understand the IEP process, or to get the documentation that they need, of having raised their concerns with the school or the school's response in a prior written notice, things like that. And then of course, don't overpromise.
So, excuse me, good afternoon. Again, I'm Diana Wiles. I'm Associate General Counsel for Prince George's County Public Schools. And before I get into the this particular slide and the information on who's a parent, I do want to say I'm happy to be able to have the opportunity to present to you all today, despite the fact that parents we may have some challenging meetings, IEP meetings, and situations with our schools and with parents. It is a great opportunity for us to be able to collaborate, and for you all to know that it is our goal within the school systems, not just Prince George's County, because I've had the opportunity to work in other districts, but that we really want to work with the advocacy and the legal community to ensure that we are getting services appropriately to our students. So on that note, we wanted to start off with who is a parent, because some of you may have some experience if you're attorneys with custody issues, may have done some of that work. But this is a topic that we see regularly in the school system because of students who may be in DSS custody, students who may be living with family members, and it's so important for the IEP process to move smoothly so that for us to know who actually has educational rights. So of course you have the natural parents, the mother and the father who are on the birth certificate, or presumed father if the couple is married. Adoptive parents, of course, would be appropriate parents for educational decision making. Within the school system and in the law, there is informal kinship care. And what that is it's a living arrangement where a student is living with a relative because the parents are unavailable. And the statute states specifically what unavailable means. So it could be a parent is incarcerated, a parent is in military service. There's a list in the statute. So if you happen to receive a client that has an informal kinship care arrangement, then reach out to the respective pupil accounting or student enrollment office for that LEA or local educational agency, because there's a process for that relative to be identified as the relative who has informal kinship care. And through that process, they're able to make educational decisions for the student. There's also the parent surrogate process, and we see this in a couple different ways. It's a student who doesn't have an educational decision maker, but typically we see it when we have students who are in DSS custody and care, and DSS has limited educational decision-making rights. What that means is that they can enroll a student, but at the IEP table, they cannot make those decisions. So it's important to work with the school system who has the obligation to find a surrogate for the student. We have a process through our special education departments in each of the LEAs to identify a surrogate for students who need an educational decision maker. Then there's guardianship, which would come by way of a court order. And again, we see a lot of court orders in our school systems. So if there's a question about guardianship, your client should be able to provide you with that order. However, you can also ask for that when records are requested if the school has any record of a court order. You can go to the next slide. The next one is foster parents who may have limited guardianship for educational decision making. So that would be in the court order. So it's important that when you do receive a client, if you have a court order, to make sure that you're looking at it so that the appropriate people are being invited to the IEP meeting. Sometimes that causes delays in the process, because if the school team does not have, whether it's the foster parent or a parent surrogate who's been identified in a court order, or whoever it may be, if they're not at the table, then that may cause delay. We may have to reschedule a meeting. Legal custody is your legal and physical custody would be your court orders that identify who the student, in the case of physical custody, lives with primarily, and in the case of legal custody, who has decision making. And in that legal custody the court order that identifies who has legal custody, it could be joint, and we see a lot of joint legal custody cases with students who have IEPs, where the parent and parents are in opposition. And so what happens in those cases, you have, for example, father who doesn't want the student to be evaluated, mother who does. And so we work through those issues with our school teams, and that may be something that you see. We, as a school system, do not get in the middle of those decisions. Our obligation is just to follow the court order as it's written, but we don't take sides. We don't try to lean one way or the other. I've had some cases over the years where one parent would, the parents were so at opposition that they were going back and forth, and it was really putting the child in a bad situation. So if you get those cases, it's important for us to work with you as advocates and attorneys so that we can try to move the case along for the best interest of the student. And then, of course, custody orders are permanent until they're not, and you have a subsequent order. What we have seen, though, with Department of Social Services and case managers and social workers who are assigned to cases, they will frequently think that they can make educational decisions in an IEP meeting, and we have had to tell them regularly that they don't have that authority. And so if you have a case where a case manager or social worker is involved, please help us to let them know that there needs to be a parent surrogate, or if there's no one named in the court order, then typically the parent still has educational decision-making rights. And Disability Rights Maryland has a document that is linked to this slide, Megan, if you want to go through that.
Sure. So we had just created this internal resource. I don't know if I click it while I'm in presenter view, if it'll open it up.
It will.
Should. Okay. Oop,
Oh,
it's not letting me
yes.
access it.
That's probably
All right. Well, we'll make sure that that you have access to that document after the training. We were intending to provide it as a resource. It's something we rely on internally at Disability Rights Maryland when we are trying to navigate concerns about who the parent is, particularly concerns with DSS and court orders that are potentially unclear about who has decision making. So was there anything else you wanted to say on that slide, Diana?
No, I'm finished with that one. Thank you.
Okay. So the next thing that we wanted to talk about is the intake process and obtaining records. Peyton had let us know that MBLS is advising parents when they contact the special education program that they should begin to gather documents. This is something that we at Disability Rights Maryland in our work have found very helpful, because while oftentimes, while schools are required to give copies of documents at every meeting, we find that a lot of the time parents are having a hard time keeping everything organized and keeping track of all of those records. And so it can be helpful. They can come to us often and articulate their concerns, but it can be hard to put together legal arguments without all of the records, and it can be slow to request all of the records through the districts, where there can be a 45-day time frame for a return of a records request. And so it can be helpful if the parents start requesting those records. It can also be helpful to narrow the scope of what you need, given the specific purpose of your representation. So just some considerations are what do you need, and can the parent obtain that potentially more quickly than you can? If you do need to request something from the school district, you'll need a release of information to send with your request to authorize the district to disclose those records to you.
One of the questions that Peyton sent to us that you all asked was for us to identify areas where Maryland's law goes above and beyond what IDEA has. And it would have been a little difficult to do a real crosswalk, because there are several areas. Maryland is one of the states that has decided that it wants to legislate above what the IDEA requirements are. But what we did is we picked out some of the things that we see on a regular basis that you should be aware of as you represent your clients. The first one is the 5-day document rule, which requires school systems to provide 5 business days before an IEP meeting and 5 business days after an IEP meeting first, the documents that are going to be used during the IEP meeting. So that could be draft IEPs. It could be uh, grade reports. It could be teacher reports. It could be anything that's going to be reviewed during the IEP meeting. The parent should be provided a copy of it. And I'll say parent inclusively, whoever is the parent or guardian. But they should be provided those documents 5 business days prior to the meeting so that they have an opportunity to review it. After an IEP meeting, the prior written notice, the IEP that was developed during the meeting or any other documents developed as a result of that IEP meeting would be sent home to the parent. It's to summarize what occurred and to document any revisions that were made. With regard to the transition age, in IDEA, the transition age is 16. In Maryland, we start to do transition planning the year that the student is going from 13 to 14. So usually in that 8th grade, if the student is a traditional age grade student, we start planning during that 8th grade year and doing transition plan, transition goal, transition assessments. Consent for alternate learning outcomes and assessments. This law was passed, I think, in 2017 or so, or 2015, somewhere around that time. And what the law requires is that if a student is not learning using the state standards, the curriculum for general education students and most other special education students, so they're using alternate or modified curriculum and modified assessments, the parent has to sign consent for those assessments. In the school system, if we believe that if there's a disagreement, so we have an IEP meeting, there is a form, it's called an Appendix A, that the state requires to be completed to determine who is eligible. The benchmark nationally is that about 1% of all students who receive special education services would be using an alternate curriculum and alternate assessments. So the Appendix A is intended to reduce the number of students who are not working in a general education curriculum. So in an IEP meeting for a student who has a significant cognitive disability, the Appendix A would be reviewed, and then the parent has a period of time where they consider whether or not they want to consent. And Megan, you can jump in if you remember the number of days. I think it's 10 days or 15. I can't remember off the top. 15. Yes. And if the parent does not respond within the 15 days, then the school system can proceed and implement the IEP, meaning they can implement it with the student being in alternative learning outcomes and alternative assessments. The parent can say no, which means that the school system has to implement the general education curriculum. And the law says that the school systems can file due process if they believe that the parent should have consented to alternate learning outcomes or assessments. I've been doing this for many, many years. I have never filed that case. And it is not to say that it is not appropriate in some instances to file that case, but it doesn't come up regularly. Usually school teams can work well with parents to get to a place where if a student absolutely is not making progress in a general education curriculum, that even if it takes a couple years, we get to where the student is appropriately learning with alternate outcomes and assessments. The next one is consent for restraint and seclusion. And that, again, was legislated around it. Both the alternate learning outcomes and assessments law changed at the same time as restraint and seclusion. So parents have to give consent for either one. That does not mean that a school system cannot restrain. They can still restrain in the case of an emergency situation where the student may be a danger to himself, herself, or others. In that case, the IEP team is required to convene a meeting to review that instance of restraint or seclusion in a non-public. About 3 years ago, the legislature changed the seclusion law so that no public school should be using seclusion. Public schools have gotten rid of their seclusion rooms. Many converted them to sensory rooms or other types of rooms to support students, but no public school should be using any kind of seclusion anymore. There's some reporting requirements for us in the public school system when a restraint or seclusion event in a non-public school where we send our students occurs. So what MSDE now requires is that if there are more than 10 seclusions in a school year, that MSDE is notified and the school system has to develop a corrective action plan. And whether that is in a public school where restraints have occurred or in a non-public school where seclusion or restraint has occurred. So those would be additional IEP meetings that potentially would occur to review those instances with the parent. And then finally, a recent change was the IEE request. Maryland requires that if a request for an independent educational evaluation is made, that a school system responds to that within 30 days of the request. If the parent does not receive that response by 30 days, then the school system has to fund it.
The one thing I wanted to add on this slide specific to the consent requirements for the alternate learning outcomes and the restraint and seclusion is that a lot of parents will equate not signing the form to allow for those as not consenting, but the law actually sees not signing and returning as passive consent. And so it's not just that parents have to not give consent, they have to actually write on the form and sign the portion that says, I do not give consent, because if they leave it blank, it is actually the same as giving consent, not the same as withholding.
And I would also add what MSDE has a really good guidance document on consent for ALO. So if you Google that and look at MSDE site, if you have that case, it'll give you some good information, background information, if you haven't had a case where you've had to deal with consent for ALO.
We have a couple of questions in the chat. The first one is 5 days after an IEP meeting, should the IEP be closed and finalized, or does this include sending a draft IEP 5 days after the IEP meeting?
So there's nothing in the regulations or the statute that talk about closing IEPs. That has become a term of art in Maryland because of the Maryland online IEP system. The IEP that you receive after an IEP meeting should be the IEP that was agreed upon during the meeting. If there are things that have not been properly documented from your vantage point, or if there are things that are missing, then one of two things can happen. One of two things has happened in my experience. An attorney or an advocate would send an email and say, hey, there's some information that didn't get to the prior written notice, or we agreed to add an objective under the math comprehension goal. And the team agrees and says, oh, it was a mistake. Someone forgot to put that in there before I sent the IEP home. And then the IEP can be amended by agreement without a meeting. If, however, there are substantive issues that the school team says, we feel like we sent you an IEP that has all the information that we agreed to, and you feel like it is, or your notes say something different, I would suggest you still send that email to the school, but there may be a need for another IEP meeting to resolve any misunderstandings, miscommunication, or disagreement. In which case, there may be a disagreement that is substantive and requires the parent to exercise their due process rights.
Thank you. The other question is there a rule on whether schools must provide post-IEP documents electronically or as paper copies?
There is no rule, and different districts handle that in different ways. And oftentimes, different schools will handle it in different ways, depending on the preference of the school team, the parents. Some parents like for things to be placed in their child's backpack. In Prince George's County, we have an email verification form that we ask parents to sign at the beginning of each year to show that they don't mind getting information by email because, for security reasons, for FERPA reasons, we want to make sure that who we're emailing is the person who should receive the documents. So there's no law that that says either way. It's really more of a preference.
Yeah, and one thing I want to add on that, again, this I think goes back to what I was talking about being prepared that sometimes rural districts do it differently. There are districts that will not send anything electronically to a parent, to an advocate, to an period, will not send student records electronically because their IT or whomever has said that they can't properly secure their messages and so that they can't do it. So they will send only hard copy files to the parent, only hard copy files if you request the educational records. And that's another area where it can really slow things down in that record requesting process at the beginning, unless you have a parent who's able to go and pick the records up and scan them to you, or rely on folks who are supporting the parent more locally.
Thank you both.
All right, IEP process timeline. So this is a quick summary of the timeline from initial referral to reevaluation for a student. The timeline starts with the initial referral, which needs to go to someone that has some authority. So parent can't give the initial referral document to the custodian when he comes and opens the door and drops it off. That is not proper notice to the school system. So a teacher, an administrator, a counselor, someone from central office receives an initial referral, whether it's by email, a letter, what have you. That starts the timeline. And most districts will say, we will schedule a meeting within 30 days of receiving that letter. That is not in the statute or the regulations. It's a practice that the districts that I've been follow. And it really is aligned with the timeline for getting that initial assessment completed. After that, the IEP meeting is scheduled within that 30 days, and team determines if they want to evaluate the student. From the date of consent, you have 60 days to complete the assessments and get back to the table to review them and make an initial eligibility determination. Now, where the timelines get tricky is the 60 and the 90 from the date of initial referral. And so the regulation is COMAR 13A.05.01.06 that talk about the 60 and the 90 days. So if you are counting the days, just keep in mind what is the first date of that initial referral and what's the notice of consent date. And whatever comes first is when you need to have that meeting for initial eligibility. In any case, it shouldn't go beyond 90 days. After that initial referral timeline, and assuming that a student is determined to be eligible, the team has to come back within 30 days to develop the initial IEP. Once that IEP is developed and the parent receives it, then the onus now is on the parent to sign the IEP. School team cannot implement anything in the IEP until the parent has signed it. So please, if you are in that situation, whether it's through MVLS or you have other clients, please encourage your clients to sign the IEP as soon as possible, because they are not afforded any of the due process procedural safeguards or services for their children until they sign the initial IEP. And just a note, after that, they don't have to sign the IEP anymore for reevaluations. After the IEP is signed, annually, you'll have an IEP meeting to review and revise the IEP. And then every 3 years, the IEP team has to come back and determine continued eligibility. Within the year life cycle of an IEP, there can certainly be other meetings, and most of the districts in their processes will have a rule of reconvening if a student is not making progress after a quarter. So when those IEP progress reports come out, they'll schedule an IEP meeting to review and determine if any changes need to be made.
All right. The next thing we wanted to cover is it says adversarial versus non-adversarial advocacy as the title. I like to think that it should be non-adversarial advocacy at IEP team meetings. That I think is the most effective. Of course, it's up to you all to determine the best approach as the student or parent's advocate or attorney. But one thing that has always struck me in my work on behalf of students is how often there are not disagreements, but misunderstandings. And I think it's partially because, and this is something that we'll cover on the next slide, but I think it's partially because of the jargon that we use in special education and parents' unfamiliarity with our jargon. So a parent might be using a word that means something else to a school district person or vice versa. And it can lead to, again, like misunderstandings, not necessarily disagreements. And so I think that it's very helpful to have a preliminary phone call with the school district attorney whenever possible, particularly if it is a school district attorney who I find more difficult to work with. Like the more difficult I think it will be to advocate in an IEP meeting, the more likely I am to call ahead of time so that I'm not catching the school district off guard with our position. Because like I said, a lot of the time, there has been a misunderstanding. And if I can clear that up before the meeting and I can come in on the same page as the school district attorney, at least about what the issue is, if not about the way that we resolve it, I think it can lead to a more successful IEP meeting. Because if we all are talking about the same thing, that's the first step to getting to some sort of resolution. The equivalent to that, is preparing for the IEP meeting by helping, by determining where the school district is coming from and helping identify for the district where the parent is coming from. And during the IEP meeting, again, being curious and listening to understand, asking more questions rather than just listening to respond to what the district's saying. Attorneys generally will communicate with school system attorneys. In some instances, it will also go through compliance for attorneys, but the best course of action is always start with the school district attorney, let them bump you to whoever they have handling their cases. Advocates will work with central office staff or with the district compliance department in cases where there are difficulties with school-based teams. This is the slide I was sort of previewing. Managing expectations prior to meetings. One thing, the way that I think about that is I generally will explain to parents that I do not act necessarily like a lawyer in a meeting, right? I'm not going to be cross-examining school district folks. I'm not going to be looking like a courtroom TV lawyer, right? I'm going to be asking questions. I'm going to be getting curious. My goal in a meeting is to get the school district to explain their position. so that we can understand, because if we have a disagreement, it does no good to shout about it. It just, the helpful advocacy strategy is to get them to write down, to get us to a clear understanding of the disagreement and clear documentation of the disagreement. And so, like I said, I like to preface meetings by saying that to parents, so that they understand I am still being a zealous advocate for them. I am still protecting their interests, even if I am not acting impolitely or, angrily during the meeting. This is the part I alluded to on the other slide, breaking down jargon, clarifying language parents have used in the past. The number of times that a parent has asked for a modification and the district has said, this student doesn't qualify for alternate standards, and the issue is actually just, we need to call it an accommodation, but actually we're all on the same page that the student needs it. Like, it happens way more often than it should. And it's because there are so many words thrown around in IEP meetings and so many issues raised that people can get really entrenched and defensive. And so sometimes just backing up and describing things differently and trying to step away from the jargon can help. Another thing that I find really helpful, and this gets back to something we mentioned at the beginning about setting parents up to be able to be effective advocates after you're done with your representation, is empowering them to ask for explanations of terms used during IEP meetings. I generally start my representation by letting parents know that with or without me there, they are entitled to understand what is happening in that meeting, and that it is not a sign. A lot of parents will feel like it is some show of weakness or like lack of education on their own part to ask questions about the way that things are happening in IEP meetings. And what I tell them, and I try to tell almost all of my clients, is that the school district staff went to school for the purpose of education. So they are very familiar and trained in education terms. And, IEP chair people receive training on the process. We as lawyers and advocates are sitting here in a training on this process and take time to, and it is our job to interact with these words and these terms and these processes. And so of course we know them, and it's not any fault, any flaw on the parent side if they don't. It's, if anything, a flaw in the way that we are advocating or school district staff are conducting the meeting if the parents aren't able to keep up. So if anything, it is holding school districts to their obligation to ensure parental participation by speaking up and asking for an explanation that the parent needs during the meeting. And so I try to frame that for parents as a show of strength rather than a show of weakness, and making them understand that their ability to understand the meeting is fundamental to the process working correctly. The other piece of this, of course, we had mentioned non-adversarial advocacy. Sometimes advocacy has gotten adversarial before we get involved. And part of our role can be to help repair that relationship, not in the formal way that schools do it, right, with restorative circles and things, though I have advocated for restorative conferences for parents and students before, as part of a school discipline appeal. But we want to make sure that our representation isn't further deteriorating the relationship with the school system, and we want to help the parent focus on the issues and not the people involved as much as possible.
I will say this is where Megan and I differ, because I am very much the attorney in the meeting for the school system, and it's not because I am there to be adversarial or to question as if we are in a litigation type of situation. But generally, if there is an attorney involved from a school system, at least the larger ones, you'll also have someone from central office there from the Office of Special Education or the compliance office within special education. And so they really are there more to address some of the tough questions that may come up that school-based staff may not be able to answer, or if it's you all would be involved with cases where there may be a change of placement. So those central office folks would be there to help support that discussion. That is not my role. So it's a little bit different for those of us who are the representatives, the legal representatives for the school system.
And that's a good point too. I think that a lot of times it can feel frustrating for parents to leave things unresolved at the IEP meeting, that sometimes the best way is to get, again, just documentation of what the team thinks the student needs or the parent thinks the student needs, and then to hash out the legal issues afterwards. Because as Diana said, a lot of school system side folks will feel much more comfortable explaining and talking things through outside of the meeting, lawyer to lawyer, rather than in front of an IEP team. That had made me think of one other thing, but I'll try and remember it for later.
Okay. One of the things we didn't put in here that I did want to mention before I forget is releases of information. So if you don't already have a release of information, please develop a release of information form that has all the information about your client and their authorization for you to access information. If you don't intend on contacting a school or compliance, or if you're an attorney contacting an attorney yourself, you don't need it. But oftentimes we do need to speak, and we may need to speak before or after an IEP meeting. And the FERPA does not allow us to have those communications. Where I've run into some challenges with advocates and attorneys is that are not familiar with this work, is they get a little frustrated when we say we can't talk to you because we don't have a release. So Megan, Disability Rights Maryland, immediately when they have a student who they're representing, the first thing we get is their release of information. So in the process, we wanted to talk about what this means, because this will come up sometimes where a student who is not currently determined to be eligible may have some rights under the IDEA. So we wanted you to be aware of this situation. So what that means is that the student is known to or suspected to have a disability that falls into one of the categories under IDEA. And the question is, does the disability require the provision of special education services? The key time when this matters is during disciplinary situations. So if a student is proposed for an extended suspension or short-term, multiple short-term suspensions that equal 10 or more for a school, or more than 10 days for a school year, a request for expulsion. So if you are representing a student who needs to have a manifestation determination meeting, but they are not eligible or do not currently have an IEP, if they have a suspected disability or they're in the process of being evaluated, they're covered under IDEA. In the process where there's an evaluation is easy, because it's schools know if I'm testing a student and they do something or are suspected to have done something that would require disciplinary action beyond 10 school days, that I have to have that manifestation meeting. The hardest situation is where you have a student who is not currently in the process, has not had that initial IEP meeting, does not have a referral. There are situations where the student may have that there may be a child find issue there, and that the student may be eligible to be considered a student in the process. So in those cases, the school team may not automatically move towards having a manifestation determination meeting, because that doesn't happen often. But part of your advocacy should be, if it is a student that has a suspected disability, to raise that as a concern for the parent. And that applies both under IDEA and Section 504.
Okay, I remember the other point I was going to make, so I'll put it here at the top of rapid fire issues. One of the things or perceptions, I guess, that sometimes parents have is that central office staff or the amount of staff coming to an IEP meeting is like a bad thing or a district being defensive. And parents will feel like, why do they need so many people, or why do they need someone from the district? And while I will often push back on delays caused by waiting for staff or delays caused by staff not being there, what I always want to tell parents is that more people are actually better able often to find the resources that your child needs and to think through all of the issues and to make decisions. And so for the most part, I like to reassure parents that 8 people, 9 people, 12 people at an IEP table is not a bad thing, is not stacking the cards in some sort of way, but it's getting more decision makers there and getting sometimes more power to commit resources, and can actually end up being a more productive meeting. But I have had parents sometimes say, like, why is someone from the district coming? Why is someone from central office? And so it's not infrequent that I end up reassuring parents, like, actually that person can be really helpful for this meeting and could really move this in the right direction for us.
Megan, can I just add something with that before you go to the slide? And I cannot remember the citation in the regulations, in the IDA regulations, but where team members are listed, it talks about a person who can allocate district resources. And so one of the things that you can say, to Megan's point, to your client, is if there's a discussion about whether or not the current school can implement the IEP, school system needs someone there that can allocate district resources. So a principal cannot allocate transportation from to another school. They cannot allocate resources to an autism program at a different school. So that is the importance of having someone from central office at those meetings, because they have the ability to allocate those resources.
All right, some rapid fire issues. It can be difficult to work with clients in a different part of the state. I actually feel privileged to be living in a state as small as Maryland, having started practice in Florida, where I was often 9 hours or more away from my clients. So I actually started my practice doing phone or virtual meetings primarily, and it was only later where I was actually able to do in-person IEP meetings. So I personally felt very comfortable when we moved to more virtual practice in Maryland during COVID, because it was something we'd already long been using in Florida. But it can be tough. It can be tough to have clients who you can't drive to their house to drop off the forms you need signed. And that's where relying on local partners, relying on the folks that they've tapped into the resources in the community can help. Sometimes it means getting those names of people and their numbers and calling them myself, so that I can rely on that resource. Sometimes it means getting permission from the parent to talk to the grandparent or the aunt or the uncle, if the parent is a long haul truck driver or works the night shift and isn't often available. But strategies for working with folks in different parts of the state, I think we've pretty much covered. Virtual versus in-person meetings. I generally tend to think that for most meetings, I can be equally as effective virtually as I can be in person, with the caveat that I need to make sure that my client is prepared for that. I generally rely heavily on text communication with my clients when I am doing virtual meetings. Unless they're also virtual, sometimes I'll do email, but for the most part, it's text, because I want them to understand. I want parents always to understand why I am taking the advocacy steps that I am taking. And it can be very hard when you're not physically with them, but I find that text can really help alleviate that issue. And so being able to shoot parents, and I use a Google Voice number, I don't use my actual cell phone number, but being able to send parents a text and say, I hear your concern, like, let's talk about it after. But that's where the work that I also do ahead of the meeting comes in as well. So letting parents know the purpose for why you're going into the meeting, remaining in communication, even informal, quick text communication of like, heard that, we'll talk about it later. We'll definitely address this, but we'll do it after the meeting. That those kind of messages can really help keep things on track. Location of services, with LRE and location not being the same. This is another like accommodation modification, common confusion for parents. And so just making sure that everyone is really clear about the language that we're using. Are we talking about a type or amount of service, or are we talking about a physical classroom or school? And when is, which is related to an actual IEP discussion and which is outside the scope. Student participation is something that I like to flag. Particularly, I do a lot of work with transition age students, so 14 and up. It is, in my opinion, nearly impossible to plan for a 14 or older student without having their input, because you're liable to go into a meeting and ask for something that they don't want. That is also true at the middle school level, especially as well, and can be true as young as elementary school, right? It does me no good to advocate for speech if the student is going to refuse to go to speech outside of the classroom. I'd be better served figuring out what their interest or preference is and engaging them in the discussion. And maybe that means putting the service push in, or maybe they prefer pull out, but knowing what they want can help immensely with advocacy. I have also had students participate very meaningfully in manifestation determination review meetings where the school was going around and around trying to figure out what why the student's behavior was getting worse. And a compliance person, actually from Prince George's County, said to the student, well, you're sitting here, what can you tell us? And he said, oh, well, my like reward after school activity got taken away from me and I couldn't participate anymore. So I figured, what incentive did I have to comply with my behavioral plan or work on these behavioral goals? And so, an entire team of people couldn't figure out why the sudden change in the student's behavior, and the student was able to tell us in 30 seconds.
We have another question in the chat about the location versus LRE point that you made. Carly says, getting a lot of services listed as outside of general education that can be provided in the general education setting, just pulled in the back of the room with the general education teacher. Is this true, or has this just been adopted as a common practice?
So I don't know that I have enough information to say if it's practice or the truth of it. But one of the considerations when you talk about services, not LRE, but services, and it's important to know the distinction. And if you're in a meeting with me and you start talking about LRE on page 3, I'm going to push back and say, we haven't even gotten to services. But the part of the services conversation is how much time and where does that specially designed instruction take place? Inside or outside of general education, as you asked, that inside could be in a small group and within the general education class. So that's part of the conversation the IEP team should be having, because there are reasons why that may work for some, but it may not work for others. Some students may need, if you have a student that is reading 3 or 4 years below grade level, that's working on very specific skills, phonemic awareness, phonics, it may not be beneficial for that student to be in the classroom being pulled to the back of the class to work on that skill, because they may have ADHD and they may have some attention issues that would impact them focusing. versus having a student who can use that time with the special educator in the back of the classroom for 30 minutes. So it really is something that a conversation that needs to be had by the IEP team, and it needs to be documented clearly in the IEP in the services section so that everyone is on the same page and understands how the service is going to be delivered.
Carly added to say on the service page of the IEP, it is saying that it's outside general education, but the team says that it's technically outside if they're being pulled to the back of the class or in a small group inside the general education classroom.
So without being able to look at that IEP, I can't, give any advice or explanation as to what is written and why it's written that way and what their intent was. But I would suggest to go back to the team and have a discussion about what specifically is happening so that it's documented clearly and everyone is on the same page.
I'll also add to that. I think sometimes using the various explanation boxes on the IEP or on the prior written notice can help, because sometimes something as simple as inside or outside gen ed is not going to be able to capture what we mean or want for that student, but explaining if we explain it as we think that they need someone other than we think they need a special education teacher to come in and give this instruction, or we think they need it in a small group, but they don't need to be pulled out or do need to be pulled out. But there are a lot of ways to individualize things on the IEP and to clearly capture. And so I think figuring out exactly what is being recommended and why it's being recommended and getting documentation of that, and then tracking whether it's working for the student is the best strategy.
Thank you both.
Sure. So the next 4 slides are really specific to things that you need to consider in your representation. And we talk about the areas where you might be picking up cases from MVLS. So the first one is more or less restrictive placements. This is clearly our most litigated issue, particularly, at least from my perspective, the cases we see of parents that want non-public placements and the school system that says we can provide the services and a non-public is not necessary. One of the things that I will bring up when this becomes a point of discussion, and sometimes this may be the point of contention, or where this meeting becomes adversary, is does the student need to be away from their non-disabled peers for the entire day? That includes lunch, it includes recess, transitions in the hallway, because that is part of, although it doesn't specifically state that on the IEP, because we don't typically provide services during recess. You might provide accommodations, but those are the things that teams need to think about when they're making decisions about non-public. Also, data is extremely important when we talk about placement changes, whether it's more or less restrictive. We talked about location of services already, and non-public is not always the answer. I want to say that and put a plug in for our public schools who work very, very hard to provide supports for students that they need. But the other piece to that is the non-public schools are dealing with the same challenges that the public schools are dealing with in terms of finding teachers that are licensed, filling vacancies and retaining their teachers. And all of us in the school systems are competing with one another for limited number of seats in non-publics for students who really need them. And so it has become very challenging because even when we know a student needs a non-public, we may not be able to move them as quickly as possible just because of the current state of special education. Where a school is proposing a reduction in instructional related services. Again, that needs to be a conversation that's heavily relying on what the data says. So if I'm talking about removing OT services, for example, or significantly reducing them or moving from direct service to consult, then the questions that the team should be able to answer is, what does the data say? And that is a question that I will most certainly ask a team to be able to produce the data, because it isn't fair to remove or reduce a service without that data.
So would you mind repeating that information about data when it comes to placement?
So when we're talking about, if we're talking about placement in a non-public school, the team is looking at data. So I guess the best example is students that have some significant behavioral concerns. Non-public schools have a choice. They can take who they want. But many of the schools, well, most of the schools, if it's a student with behaviors, will require a behavior intervention plan. So if a school team has not done an FBA yet, just by way of example, we have situations where either a school team is pushing for a non-public because the student has significant behaviors, or a parent may be saying, this is not the right placement, my child needs a smaller setting, we want a non-public, we've already identified it, when do we start and how do I get there? The data is important, because if student doesn't have an FBA, or doesn't have behavior goals, the IEP team needs to do that FBA. They need to develop that BEP. They need to determine where those behaviors are coming from, because sometimes we see those behaviors in students that have just dealt with a traumatic event. And so is it fair to move a student to a more restrictive placement when they've had a death in the family, or they've had some other trauma that just requires us to identify the behavior and address it where they are? So that's what I mean by data.
I also, and Peyton, I saw the follow-up question, but I want to jump in with something related to what Diana was just saying first. Speaking of the non-public schools and the least restrictive environment, I find it very helpful when talking about repairing relationships and non-adversarial approaches. I generally like to help explain to parents that the reason that districts sometimes hesitate to put students in non-public schools is that the law favors, stresses, emphasizes inclusion in general education as much as possible, and to remind parents that that's not to keep students from getting services that they really truly need, and it's not the district trying to put up roadblocks, it's the law purposefully putting up roadblocks to prevent what we saw back in the 70s, which was the warehousing of students with disabilities in basements. And so reminding parents that, like, it can be very frustrating, and acknowledging that it can be very frustrating to move incrementally through this process when you feel like, but if we just change this one thing right away, it would be successful. But reminding them that we're coming from a place of, we were putting way, way too many people in very restricted, very isolated, hidden away placements. And so the law purposefully made it very difficult in order to make sure that we are trying everything we can to meet a student's needs before we are resorting to taking them away from their general education peers. I think that ties into the question, the clarification of the question that was in the chat about access to disabled versus non-disabled peers during recess, lunch specials, things like that. That's an important aspect of the least restrictive environment, even though you might be fully in special education for your academic curriculum. If you are at a public school that has general education students, you can still, as appropriate, see them during lunch, recess specials, or have the opportunity to gradually start to be pushed into those type of settings. And so being in the same school building, being in these non-academic times with students without disabilities can have incredible value for students. And so putting the supports and services behaviorally, social, emotionally into a more inclusive setting can have benefits, and that's why the law requires us to think not just about what do they need during their academic instruction, but globally what type of school can best support their needs, including their need to be exposed to general education peers, because, you know, evidence shows that both for the general education peers and for the students with disabilities, that time outside of academics or in academics, interacting with people who are different than them, is incredibly beneficial. And that's something that each team considering a more restrictive placement needs to take into consideration and weigh that loss of exposure to general education peers.
Thank you both.
Okay. Another issue specific to the MVLS special education program is when the school has suspended or otherwise removed the student for over 10 days. We flagged for you and put the citation for the limitation regarding students in pre-kindergarten to second grade who can only be suspended in very limited circumstances, which is when a school mental health professional has been consulted and has determined that the student poses an imminent threat, which can't be met with other measures. And even in that case, for no more than 5 days. I will sort of jump ahead to the interim alternative educational settings piece of this, because I have seen that come into play very recently, where a student in pre-K to second grade was assigned a 45-day change of placement to an alternative school, purportedly because of the IAES. My position legally is that you cannot serve a longer removal through an IAES than you could have served through the pre-K to 2 suspension regulation. It gets tricky. This is one of those areas where if we cross-referenced the IDEA and Maryland law, we would see, you know, Maryland law is more protective for students in pre-K to second grade. Maryland law is also more protective in the general education discipline protections for long-term suspensions and expulsions. And so in both those areas, pre-K to 2 and for everyone, long-term suspensions and expulsions, our Maryland law is more restrictive about who can receive that type of discipline than the IDEA necessarily envisioned. And so while 45 days as a limit to the amount of time a student can be removed to an interim alternative setting, for a lot of states where you might be removed for a year or a semester, 45 days is going to be better. In Maryland, 45 days is way more than that pre-K to 2 student could have received, or more than a long-term suspension could have been. And so my position has been that general education discipline protections in Maryland, so protections that apply to all students that are more protective in Maryland than in federal law, should come into play. And so a student should not have a longer interim alternative education setting removal than they could in Maryland legally have been suspended. We also wanted to flag, I guess related to that, I'm going to go backwards here, the manifestation determination review and superintendent designee discipline conference. The manifestation determination review needs to happen after the student has been suspended from school for 10 cumulative or consecutive days. And beginning on that 11th day, the student needs to have access to their special education and related services, FAPE services, regardless of if they're returned to school. And if the behavior is found to be a manifestation of their disability, then they are to be able to return to school, unless it meets the limited exceptions under the IDEA for Gun-Free Schools Act. I did not specifically say drugs and weapons. That's another area under the IDEA you can be removed, but in Maryland, the criteria is different. And so just watch the interplay between IAES, where it's allowed under the IDEA, and what Maryland law requires or allows for general education discipline. The superintendent designee discipline sorry, Dana, did you want to jump in? Okay, the superintendent designee discipline conference, the general education due process protection, that also needs to happen after. So if you get a 10 consecutive day discipline removal, it will trigger both the manifestation determination review if it's over 10 days, and it will trigger the superintendent designee discipline conference if it's over 10 days, because principals in Maryland don't have authority to give longer than a 10-day suspension. So it has to be ruled on by the superintendent and designee. And in order to be out for 11 days, you have to have a manifestation determination review. The way we generally see this work in practice is that the MDR happens first, because if it is a manifestation, there's just no need for a designee conference because the student couldn't be required to serve additional days. This again gets tricky with the IAES because, like I had mentioned, the IDEA allows a 45-day IAES for drugs or weapons. Maryland does not allow a long-term suspension or expulsion for drugs. It wouldn't meet the criteria, which is chronic and extreme disruption or imminent threat of serious physical injury. So drugs just does not meet that standard, and that's an area where I see a conflict between the IAES rules under the IDEA and the Maryland discipline rules. In those cases, what I have asked school districts to do is to hold the manifestation determination review and determine whether the behavior was a manifestation of the student's disability. If it was, and it doesn't meet IAES criteria at all, immediately return the kid to school. It doesn't matter. You don't need a designee conference. If it would, under the IDEA, meet IAES criteria, then I have argued that before actually moving the kid to the IAES, the superintendent designee should weigh in about whether a general education student could be disciplined for that same behavior. And if not, then the student should be returned to their setting just like a general education student would be.
The next area of consideration, if you get a case where the school has requested a due process hearing. We do not typically file due process against parents in most school systems. However, in a limited number of situations, a parent may be, a school system may file due process. The first one is to force consent to assess a student in an initial eligibility situation. This does not happen. I've never had that case. And the reason is because we can file due process for consent to assess, and ALJ could say, yes, you can assess a student, but then once we assess them and say you're eligible, we can't force the parent to sign an IEP. So school systems typically don't spend the time to go to due process to force consent, because we just will have evaluations. We still won't be able to initiate services. Independent educational evaluations, where we have said we've responded within the 30 days of the request for an IEE, and we've said that we feel like the psychological or educational assessment that we did was appropriate, it was reliable, it was valid, then we are required to file due process and to defend those assessments. And school systems are doing more of that because we are getting more requests for IEEs, more within the last couple of years than I've seen in 15 years. And we do have some excellent evaluators in our school systems. I think sometimes the reason why the IEE request is made is because there isn't necessarily disagreement with the evaluation. There's a disagreement with what the evaluation leads up to in the IEP. And so that might be something that you want to communicate with a client if there is an IEE defense case that comes your way. And then there are some infrequent cases, as I mentioned earlier, the consent cases for alternate assessments. School systems can file due process. Limited cases where a school system may want to force a change of placement, where a student may be in their homeschool and the parent has said, absolutely not. You're not moving my child to a non-public, and the child may be having some very unsafe behaviors. A school system may file due process. The next area is restraint and seclusion. So we talked about this a little bit earlier. The one thing I want to point out here, or a couple of things again, is once we get to 10, we school district have the requirement to convene an IEP meeting and develop a corrective action plan. But the other piece for you to know about is properly counting numbers of instances of restraint. And so a restraint is anytime you go hands on and it meets the definition. So it's not a teacher puts their hand on a child's arm and moves them to the next class. So a restraint is a very specific thing that is it's very specific. On the other side of that, once a restraint is initiated, if the staff goes hands off and they go on again, that's 2 restraints. So even if they restrain for 30 seconds and then they move and they think the child has calmed down and they haven't, and they have to go back in and do another hold, then that has to be counted as multiple restraints. So that may be a question that comes up in any of the cases that you might receive.
Okay, back on alternative schools again. One of the types of cases specifically is when the school has proposed to enroll the child in an alternative education program and the family disagrees. For IAES, like I mentioned on the previous slide, weapons, drugs, and serious bodily injury are the big 3. In Maryland, you also need to think about how that plays in with the general education standards. Again, I called out drugs as the clearest example to me because in Maryland, in the IDEA, they call that out as something that can give you 45 days. In Maryland, you would need to be a chronic and extreme disruption to be suspended for up to 44 days, so 11 to 44, and you would need to be an imminent threat of serious physical injury to be suspended over 45 days, and generally, drugs isn't going to meet either of those criteria. In Maryland also, it's imminent threat of serious bodily injury, so not past serious bodily injury. And then we also have a regulation that comes up sometimes, especially in some of the smaller districts. Their alternate education program has an online component, or might be online, and there is a regulation in Maryland that the educational placement for a student subject to school discipline cannot be virtual school, and so keeping an eye out for that. Reportable offenses also come up as a reason where schools can change the placement. Some things to look out for there are whether the school team is meeting to review the change in placement for a reportable offense every 45 days. Behavioral threat assessments are an area where a student cannot be removed solely for a behavioral threat assessment. So a school can seek to have a behavioral threat assessment done, and if you have a 10-day suspension, you can serve your 10-day suspension, and maybe your assessment's getting done during that time. But what can't happen is you get a 10-day suspension, and then on day 11, you're told you can't come back because you have a behavioral threat assessment outstanding. That would actually then become a long-term suspension of 11 to 44 days, in which case the school would need to go through the formal discipline process to find a chronic and extreme disruption or serious bodily injury to meet the standard. The behavior threat assessment alone is not a reason to keep the student out. Administrative transfers can be a really tricky area, where safety transfers are certainly allowed and envisioned under the law. If a student is being moved from a regular public school A to regular public school B because of a safety reason, nothing has changed with their IEP process, with their IEP services, as long as assuming regular public school A and regular public school B have the same type of services and can implement the IEP. That is to frame it, general education process. It would apply the same to any student, even if they had an IEP. Where it gets tricky is if the administrative transfer is from general public school A to alternative school that doesn't have a special education teacher or doesn't have the related services that the student needs and can't implement the IEP, or a student, again, administratively transferred to virtual school with an IEP, which that can't be the disciplinary change of placement. So in some cases, administrative transfers can happen for students with disabilities, just like any other student. And in some cases, they would be highly inappropriate. So.
And just two things to add there. There are some state board decisions on changes of placement to alternate educational settings or other schools where the change of placement or the transfer was done in lieu of discipline. And that is a violation of the student's rights. So I would just say, keep the schools, we can't say, well, we're not going to suspend you for 10 days. We're not going to make a request for extended suspension, but go to school B or go to this alternative setting. We're not allowed to do that. The other thing I wanted to just ask is everybody, if you can just put a Y or N in the chat, are you aware of the difference between a reportable offense and behavior threat assessment, or are those new terms?
I also think it's really helpful that you called out the MSBE decisions, because I think in special education, we often think in terms of the Maryland State Department of Education, but for school discipline, especially discipline appeals, the State Board of Education has very valuable opinions and guidance on that, or gives guidance on their opinions, rather.
So quickly, because I know we're running out of time, I think we're way over time. So reportable offenses are incidents where a student has been arrested outside of school and there are specific criminal acts where the school system has to convene a meeting and there's some very specific things in the law that have to be done. Whatever happened did not occur at school. So I would encourage you to learn more information about that. Montgomery County Public Schools has a very good administrative regulation on reportable offenses. Behavior threat assessments are required where a student indicates that it may be something they say or something that they do that puts them in a position where they are either a threat to themselves or others, and the school team has to meet and determine the level of threat that the student may pose, which could be no threat up to imminent threat. And then a determination has to be made about how to keep the student safe and how to keep others safe. And the last area for consideration, just some things to consider, is if you have a client who is not a native English speaker. All of the school systems are required to provide interpreters for parents who families who don't speak English. So reach out to the school system to find out how to access that support. Many of the school systems use language, is it Language Line? I can't think of it, but it's Language Line by phone if they don't have interpreters on staff. But when you make that request, or if you're notifying the school that you're a part of the team, ask for them to have a longer meeting, because many school teams may not, they may not have a lot of meetings where they need interpreters, so they won't plan for a meeting that might take an hour to take 2 hours because of the interpretation.
The other strategy or accompanying strategy to that, I think, is if you can't get a longer block for your meeting, get too close together while you're scheduling. Because if you have one and then you're trying to schedule the other, now you're scheduling out and your meetings are getting farther and farther apart. All right, last slide. These are just some helpful resources. The parental rights document, which is required to be provided to parents at least annually. and at all manifestation determination meetings, or when there's a disagreement with the team, to help parents, to help make sure that parents are informed of their rights, particularly their right to file mediation or requests for due process if they disagree. There's also a link to the Maryland Model IEP form, which most districts are using, and to the MSDE publications and information page. So that will take you to the main landing page, from which Peyton pulled that technical assistance bulletin or guidance document earlier. And then it's also helpful to check the local education agencies for any compliance and process guides that they have. And I'll also say for administrative policies and procedures, especially related to school discipline things. I mentioned earlier that a lot of smaller districts may not be able to send records electronically because of their internal systems. I have noticed anecdotally that some of those same districts also do not accept disciplinary appeals electronically. They require stamped in the mail school discipline appeal processes. So just something to keep in mind when you're working district to district. Take a look at the individual local education agency school board policies that pertain to these different processes, because there's a lot of room for things to be allowed under Maryland law and differ district by district. The one other thing I wanted to mention related to what Diana was saying about tracking data, tracking progress when advocating for different things in IEP meetings, like a change of placement or addition of services. Disability Rights Maryland is working on a resource to use for parents that will help make it easier for parents to see, to kind of take a look at the progress year to year, or the present level year to year on the IEP, and the goals year to year on the IEP and grade levels, and try and synthesize that all into one document for them so that they can, you know, kind of look at everything once and then put it on one paper where they can see it more easily themselves, what's changing year to year and how that's going. And so happy to share that with MVLS when we get that into place as a tool for parents, and happy to have that shared with all of you as well.
Thank you both for all of that very helpful information. I just wanted to give everyone one last opportunity. If anyone has any last minute questions, you can feel free to unmute yourself. All right. Well, thank you everyone for joining, and thank you, Diana and Megan, for your time today. We really appreciate it.
Thank you.
Thank you.
Thank you. Have a wonderful rest of your day.